Forgetting to, we talked about exams a little bit as far as 20% of the second exam comes from your participation in our IPE event, which is still to be determined. But our other exams, we actually have our first exam February 12th, which is only a month away. It's not the first exam you have this semester, but it's, I believe, the second exam you have. And there'll be more on that later. We will probably finish the material, at least one lecture. I try to finish it at least one lecture before the class. And then there's some gap there as far as the material to be on the second exam, because it comes up pretty quickly. But our exams are 212, 319, and then remember our final is early, because we're taught on a 12-week schedule. Our final will be on April 11th, and then you'll be done with law. That's actually a little later than usual. We'll finish the class at the very beginning of April, and then because of some other events that next week, we won't have class, so it gives you a chance hopefully to study the material. I always get that it gives you a chance to forget the material, but the final, again, will be comprehensive, so it does give you a chance to go back and cover everything from the beginning. That's it. That will be a comprehensive exam. Okay, so picking up where we left off, we were up to 1938 and the very big, important law, the Food, Drug, and Cosmetic Act. We talked about it took a lot of things. They had been trying to firm up the earlier Pure Food and Drug Act for many years, but it took this event to actually allow that to happen. And the event there was the sulfanilamide elixir, which killed a number of people. Never was totally documented, and most of those, unfortunately, were pediatric patients. There were many more that were injured permanently and not necessarily killed directly as a result of that. But a lot of things got firmed up, mainly now that it requires the drugs to be proven safe. The first step was not adulterated. It was concerning adulteration and misbranding. And that stayed in the act when it became the Food, Drug, and Cosmetic Act. They now added that it must be proven safe. Notice we haven't said anything about did it have any efficacy as yet, and that's coming very soon. But again, we're up to 1938, and we still haven't really required that these people marketing these drugs prove that these drugs actually do what they're selling them for. One other little caveat we need to add to the Food, Drug, and Cosmetic Act. It is, again, a federal act, and even more so at that time, there was this concern about states' rights versus what the federal government was getting themselves involved in. Who are they to tell us in an individual state what we need to do? Well, sure enough, in 1948, and again, the dates on these aren't important. I'll go ahead and say that. I'll probably say it again. I'm not going to have you memorize dates. The important thing is to know the sequence of events and what each of these laws or acts had as their main characteristics. But anyway, it said they have to be now proven non-adulterated, not misbranded, and also be safe. Well, there was an issue, and it actually has a Georgia connection. Actually, it has another Columbus, Georgia connection. There was a pharmacy named Sullivan's Pharmacy in Columbus, Georgia. And those of you that aren't familiar with Columbus like I am, one of the big things we have going for us, one of our biggest industries in Columbus is Fort Benning, okay, a huge Army infantry base. Back in the day, there was a lot of interest in entertainment to attract the soldiers and to take them away from their money. And Georgia, because of their relationship with the fort, tried to hold back on that. But right across the border, the way Columbus is oriented, was right on the border of Alabama. Phoenix City, Alabama, at that time was known as Sin City, USA. And they had all kind of vices out there, a lot of gambling, a lot of ladies of ill repute. Basically, a soldier, if they could get over there, they could get in all kind of trouble, and it was the things that they wanted to get involved in. So, the gambling, things like that, they were trying to stop. There's still slot machines and all that were thrown into the Chattahoochee River when they came in and got rid of all those things. They're still finding those in the Chattahoochee River. But the other part of it, as far as the prostitution and things like that, unfortunately, they could determine that people had been involved in this because of the sexually transmitted diseases they were bringing back on the base. And they would be cited and sometimes discharged if they had sexually transmitted diseases, but they had to go and get treatment, there on base. Well, being very industrious, Mr. Sullivan, who ran an independent pharmacy in downtown Columbus, Georgia, started selling a sulfa drug, like what we talked about, sulfanilamide, started selling tablets of sulfasalazole to the soldiers to cure this problem so they wouldn't have to get cured on base and wouldn't get in trouble. And he was making a hefty little business going with that. And he wasn't the only one doing it, but he's the one that the feds cracked down on. So again, remember the plaintiff versus defendant. Plaintiff in this case was the United States government against Sullivan, Mr. Sullivan, who owned an independent pharmacy in downtown Columbus, Georgia. The contention of the lawyer who was representing Mr. Sullivan said that the United States didn't have anything to do with the fact that Mr. Sullivan was selling this sulfa drug because he had actually purchased it in Atlanta, Georgia, through a drug wholesaler, and he was dispensing it within the state of Georgia. So the interstate commerce aspects of the Food, Drug, and Cosmetic Act should not even apply, and they should dismiss all the charges. Well, they did get him on misbranding and not properly labeling these products. He was dispensing them in a little cardboard box. He had a certain number of tablets, and of course didn't have full information on that. As you will see in a minute, this did not require a prescription at the time, so he didn't break any dispensing laws, but he did break the law as far as Food, Drug, and Cosmetic Act of misbranding or mislabeling these products. If he was found guilty, they appealed it all the way up to the Supreme Court. And this court case is still quoted today as a main example of why federal law does apply to state jurisdiction. And basically what they said was, even though, yes, that last step of that commerce had been within the state, the product was made in another state, was shipped to Georgia, and basically any component of that whole cascade of transactions that led to those products being sold to soldiers who needed them in Columbus, Georgia, happened across state lines, and the Food, Drug, and Cosmetic Act did apply. And that, like I say, this is still quoted today in cases where people try to say that the federal government laws don't apply to interstate practices. And so it's a pretty big deal. Had the pharmacy connection, had the Georgia connection, and unfortunately the connection with a lot of those soldiers out in Fort Benning. Again, this is applied nowadays to internet pharmacy practice. They have firmed up the laws as far as governing internet practice of both prescribing and dispensing medications. And we will come to another law that was on the books, the Ryan-Haight Act, which specifically regulates or gives some teeth to regulating internet pharmacy practices. And this had to do with a young man who died of a overdose of hydrocodone. Back before it was even a C2, because he had been he had a video conference with a physician, and they prescribed this to him, and he was providing this mail order, and he was impaired, and he died from that overdose. So again, it goes all the way back to this Food, Drug, and Cosmetic Act back in 1948 is when that event occurred. Jumping up now from 1938 to 1951, I know that still sounds like a long time ago to you guys, but that's kind of getting around to the time. I wasn't quite born in 1951, but it wasn't long after that. Again, think of pharmacists practicing at that time. And of course, the College of Pharmacy, UGA, and pharmacy schools all over the country have been graduating pharmacists for years by that time. But just think about the difference in their practice versus what we have today. It was not until 1951, the Durham-Humphrey Amendment, that said that some drugs were not safe to be used without medical supervision. And these should be only dispensed by pharmacists under the direct order or prescription of a, at that time, physician. They didn't have nurse practitioners and PAs by any means then. But it was the first time they actually designated the difference in these drugs that, again, that we're now going through the Food, Drug, and Cosmetic Act getting approved by the FDA, but they were able to be sold out there, and depending on where you were, from state to state, some things might be prescription, some things might not be prescription. There was no clear designation at the federal level. And so again, the practice of pharmacy was much more wide open back then than it is now. One of the main things that the Durham-Humphrey Amendment established was just two classes of drugs. One, which they called legend drugs, and we'll see what that means here in just a minute. The other one, the non-prescription drugs, or over-the-counter drugs, as we used to refer to them. The non-prescription drugs, of course, implied that those drugs did not require medical supervision. You didn't have to have a prescription, didn't have to bring that to be filled by a pharmacist. But it did require, again, for the first time ever, that it must have adequate directions for use. And I didn't add it in there, but if you read the legislation, it actually says at a language speaking of language, can't even speak, at a level of language that can be understood by the intended recipient. So again, in simple enough language, a lot of times they refer to that as like 8th grade, 6th grade, things like that. Basically very basic instructions so that somebody could use it safely and it could be sold over the counter or without a prescription. Legend drugs, what that means is they required medical supervision to be used safely, and all of those products, the dispensing container would have to carry this legend: caution, federal law prohibits dispensing without a prescription on the label, and that again designated these drugs as requiring a prescription from the other drugs, the non-prescription drugs that did not require medical supervision or a prescription. So this is the first time that began to happen. We will see this gets kind of changed a little bit in some later legislation, mainly because of how wordy that is and because of all the other things that are now required to be on the label. So they've actually shortened the legend, and now most of the time on the bottles we have in pharmacies it just says RX only. But it started out as this much more verbose legend. There were some additional very important components to the Durham-Humphrey Amendment. One of the main things, like I said, was that directions were required on those over-the-counter medications for non-prescription drugs. Again, that had never been required before, and pharmacists may label things. Again, they may sell things that maybe should have had some medical supervision. They could make up their own directions, things like that. But now this requires that those be part of the approval process and actually be applied to the non-prescription drugs. Another interesting thing that it first gave a provision